Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week it's the top 5 changes that are coming to the Texas discovery rules. You may know that the Discovery Subcommittee of the Texas Supreme Court Advisory Committee has proposed some significant changes to the Texas Rules of Civil Procedure that govern the discovery process. These would be the most significant changes to the discovery rules since the complete rewrite of the rules in 1999. These are the 5 most significant to me anyway. Number 5 is that when you state an objection to a discovery request, like a request for production, you would have to state expressly whether you are withholding any documents or information based on that objection. That's probably a good rule to have. Sometimes it's not clear from a party's response when they make a lot of objections whether they are actually withholding anything based on those objections. On the other hand, I expect this change, if it ends up being made, to be routinely ignored. We will see. Number 4 is a change that would generally limit a party to only 25 requests for production. I'm not a big fan of this change. I wrote about it on my blog. You can go check that out and see what my reasons are. But just to put it briefly, I don't think I've ever had a case of any significant complexity where 25 requests for production would have been enough. The number 3 change to the Texas discovery rules would be the requirement of having an initial discovery conference. This would be very much like the initial conference that the federal rules require. So if you're familiar with an initial conference in a federal lawsuit, this won't be that different. That's probably a good idea, although to be honest, I've often found the initial conference in a federal lawsuit to be kind of a waste of time. It kind of ends up being just a hoop to jump through or a box to check off. So I don't know if that change is really going to make much of a difference. The number 2 change, or proposed change to the Texas discovery rules, is a pretty important one. It would say that generally communications between a lawyer and a hired testifying expert would not be discoverable. That's a pretty big change from the current situation where lawyers have to be careful about what they put in writing in communicating to a testifying expert, because that's going to be discoverable. I think overall this is a good change. I think it could save clients some time and money because their lawyers won't have to worry so much about kind of tying themselves in knots to make sure that they don't have any written communications about anything of substance with their experts. Finally, the number 1 proposed change to the Texas discovery rules would require federal-style initial disclosures. Do you see a theme emerging? In general, these changes would move the Texas discovery rules to be closer to the federal discovery rules. And parties would be required to serve initial disclosures, which would include, most significantly, documents that a party intends to use to prove its case. I think this change is intended to take some of the gamesmanship out of the discovery process. It would basically say to a party, look, if you've got evidence and you're planning to use it to support your claims or your defenses, then you need to produce it. That seems like a pretty common sense change, and one that I hope will be an improvement on existing Texas discovery practice, where sometimes you have to spend a lot of time fighting over requests that basically just amount to show me the documents that you plan to use to support your case. So those are my 5 most significant changes to the Texas Discovery Rules. Stay tuned to see if these changes are approved, because if so, and if you're a litigator, they will have a significant impact on your practice. And hey, thanks for watching.